Hi there, I'm Christina Jump, and I am the Civil Litigation Department Head within the Legal Division at MLFA, at the Constitutional Law Center for Muslims in America. The Supreme Court had a really busy final week of its term. One of the cases getting a lot of attention is one that is near and dear to my heart and the work that we do here at the Law Center, because it's about religious accommodations at work. That case, called Groff versus DeJoy, was brought by a worker at the U.S. Post Office, and he didn't want to have to work on Sundays for religious reasons. The post office said that it created too much of a burden, in that it created a burden on scheduling and on other employees to have this one employee off on Sundays and other employees having to make up the work. So they said it was an undue burden using the test that exists and was already in existence from prior Supreme Court cases. And because of that undue burden, they didn't have to make that religious accommodation. And he had to either work Sundays or not keep his job. Well, that's what went to the Supreme Court. And the Supreme Court came up with an opinion that really just clarified its existing standard. Now, the Supreme Court has been at each other's throats, so to speak, on several cases, really strongly opposed to each other, and opinions that point that out and that viciously go after each other in lawyer terms. In many cases, in this one though, in this religious accommodation case, we had the incredibly rare bird out of this term of unanimous opinion. All 9 judges agreed. And what this opinion says is that really nothing's changing, but that standard that the Supreme Court set 50 years ago, that there has to be a more than minimum, more than a de minimis, or more than the minimum amount of burden on an employer before it can refuse an accommodation that an employee requests for religious reasons. The Supreme Court said that standard has just been applied wrong for the past 50 years. And in some cases, it has been applied really inconsistently. So instead of deciding whether that means substantially burden, or it's really hard, or oh, come on, guys, or whatever language anybody might use, what the Supreme Court did was refuse to pick a particular favorite phrase. But the Supreme Court said, look, realistically, it's got to be a substantial burden. It can't be just a feather more than a minimum amount, or the fact that there's some administrative costs involved. It's got to be a real burden on the employer in order to have to accommodate this request by an employee before an employer can say, nah, that's too much work, costs too much, takes too much effort, we don't want to do it. So realistically, what this does is back up what some courts have been doing in the country all along, and what a lot of employers have been doing all along. And it takes away the argument from other courts and some other employers that said, really, if I can point to any burden at all, any change on any other employee at all, then I don't have to do it. Yeah, they do. And yeah, they really should have been all along. That's what the Supreme Court said. This is good for religious accommodation. This is a good outcome to support religious accommodation in the workplace. Now, let me tell you a few things that the case does not do. The case does not set magic words, despite the efforts on both sides of this case to try to get their own preferred favorite phrases adopted by the Supreme Court. And this case does not explain, in particular detail at least, what happens if the religious accommodation requested is something that is in conflict with an agreement the employer already has between a union and the employer. So if there's a collective bargaining agreement with the union and this employee is requesting an accommodation that conflicts with that, or realistically, in most cases that this comes up, messes with the seniority rights that are set forth in the collective bargaining agreement, what happens? We still don't entirely know. That's something that wasn't firmly decided within the case. But what is made clear is that employers need to hear employees out. They need to make a real effort to make religious accommodations that employees request. Now, they don't have to give that accommodation. They don't have to give the one accommodation that an employee requests, but they need to talk to them. They need to hear them out. They need to have the conversation. They cannot just say no. And employers need to, if they don't like the one suggestion that an employee makes, make a different suggestion. Make an alternative suggestion. Go back and forth with the employee. And it is an interactive process. So both the employee and the employer need to use that interactive process to figure out, well, what can we do? What is something we can do that doesn't put a whole bunch of inconvenience on other employees? Because that's still not the case either. This opinion doesn't make it so that an employer has to accommodate every request, no matter how much of a burden it puts on other employees, no matter how hard it makes the other employees' jobs, or no matter how much it costs the employer to try to accommodate. There are limits. They're just not specifically spelled out. It's a balancing test, and it's something that employees and employers need to look at each time. So you're not necessarily going to get the accommodation that you request, but after this Supreme Court case, which goes out of its way to say it's not changing anything, there really is no excuse for employers and employees not to sit down at the table together and see where they can find common ground and see what kind of accommodations do exist so that all of the employees can continue to observe their sincerely held religious beliefs, and so that the employers can continue with their business without a real imposition on other employees or a real cost burden, not just a couple of dollars. Overall, this case, again, is good. What this opinion does with the unanimous court, so we're not even waiting for the next case to come around the corner like we sometimes are with this particular Supreme Court. We're not waiting for the next version to come up that might gut the whole thing. They all agreed. And what they all agreed on is that religious accommodations in the workplace matter. Letting employees observe their sincerely held religious beliefs matters. And employers and employees need to work together to come up with ways to do that. We here in the legal division of MLFA are going to continue the casework that we've been doing all along and that we are doing right now on behalf of multiple clients to guarantee that they get that, to guarantee that our clients have the right to practice their sincerely held religious beliefs, their religion of choice in the workplace with a reasonable accommodation. We've been doing that for years, and we're going to keep on doing it. And the Supreme Court just made it clear that that's exactly what should continue happening. Thank you.